Hi, hello, brothers and sisters, and thank you for having me here today. And today we are going to discuss about one of the important topic, that is marriage. And today in this world, marriage is a institutions which is agreed only to the men and women. They can only marry, but not LGBTQ community, according to the Supreme Court recent verdict. So before going to in this topic, we will discuss about this background and why we have to consider the marriage of LGBTQ community. So in this article written by Anand Gruver, he is a senior advocate and practicing Supreme Court of India, and he is practicing advocate in the Supreme Court, and he appeared in the Nas Foundation's Kausal case and Suresh Kumar case, Puttaswamy case, Nalsa case, Navta Johar case, and Supriyo Chakrabarti of LGBTQI community cases also. And before going to that, so let's discuss about the marriage. The marriage, the institutions, which is a fundamental right under the, we cannot say, sorry, it's not a fundamental right according to the Supreme Court, but under the United Nations Declaration on Human Rights Article 5, it reads that the men and women of full age without any limitation due to race, nationality or religion have the right to marry and found a family. That is under the human rights under the United Nations. But is this limited to only the men and women? And before discussing that, so we will discuss about the Nas Foundation case and also the Navtej Singh case, Jogar's case in 2018 verdict. It nullified the section 377 IPC 377 sections. In this context, the LGBT community can also have a sexual orientation which is not criminal so far, according to this 2018 Navtej Singh Jogar case. So the Supreme Court agreed that they are the persons, they can identify them as men or women or any other sexual orientations according to their physical orientations. They can declare them itself. According to that, the Parliament enabled the act that is called Transgender Persons Right Act. So in this act also consider them as they have own rights to have self-identifications. So it recognizes they are some humans, they are having this kind of LGBTQ, they have a different kind of sexual orientation, and we recognize the rights of the persons in this case and also in this act also. But why the Supreme Court is still not giving a fundamental right to marry or rights for the LGBT community to marry someone? So if you consider the marriage system is one of the recognized by the society. We can have even men and women can have living together or benefit with relations with benefit, some kind of relationship other than marriage can have, but still it is not recognized by the society, and it is considered as a taboo in the society, in particularly in Indian society. So marriage is the legitimate one, and even if you recognize in the section 377, you decriminalized in the Navtej Singh Jogar case, but and also you have a act called Transgender Protection Rights Act gave, and you recognize them as a human, and why still the marriage is only give rights to the men and women. So even United Nations Declaration on Human Rights, it's Article 5, it talks about the marriage system, and still it is not a fundamental right for the society. So why it is not considering, and why the Supreme Court is not considering this one is the question is asked by the author Anand Gruver, and the Supreme Court also told that it is a matter of parliamentarian, and they will decide according to the society and social norms. but giving a rights for the human and giving protecting the dignity of the human being is under the protector of the constitution, that is Supreme Court of India. So the government should consider the fundamental right of marriage for the men and women and also for the LGBT community, because they are suffering from lot of before 377 IPC non-criminalization. That time they got a lot of penalized for their sexual orientations. Now we recognized, but still we are not giving the rights for the social institutions so far called marriage system. So we have to give some kind of rights for them to marry. That is what the argument which is said by the Anand Gruber. And also he told that in the past we have a case called Kausal. In this case the article section 377 was questioned in the Supreme Court, but still the 371 is not considered by the Supreme Court, and at that time the Kausal judgment itself is talk about the criminalization. So in this future, so we can have the rights for the marriage for LGBTQ community also we may have in the future also. That is what this article discussed. So the marriage system, it is the right of choice of the persons. I'm personally consider this is the right of person choice. It should not be based on anything rewritten, anything mentioned in the traditional law or something. So they can have adoptions, they can have some kind of new family. So we should analyze and the diversity of sexual orientations and the gender. It is increasing, and we are thinking something beyond the traditions. So the rights should be diversified and the rights should be accessed by all. It should be given to every person. That is what the argument is considered under the fundamental rights for the marriage for LGBTQ community. That's all for today's article. And from this article we talks about the rights for all and also marriage rights for everyone, and why should not we consider the fundamental rights to marriage. It is because Supreme Court is not considered about the rights of marriage is not a fundamental rights, so it's not a fundamental rights, but in future cases Supreme Court also consider this one and they can make it is a fundamental rights, and society should also change their mind to address and diversify their views on this kind of issues. That's all today. Thank you for watching my video. Thank you so much, and we will see the next topic from next day. Thank you. Bye.